I'd like to welcome everybody to Orlando Sentinel's interview with candidates for the 9th Judicial Circuit Public Defender, which is charged with representing people in Orange and Osceola counties who are charged with crimes that can't afford an attorney. This year's race for the public defender in this circuit, which includes Orange and Osceola counties, is unusual in a couple ways. First off, this is a rarity in Florida politics. This is a true open primary because the only two candidates who qualified are Democrats. Everybody and every registered voter in Orange and Osceola County, regardless of your party affiliation, is eligible to vote in this race. Also, the incumbent, Robert Wesley, has chosen not to seek re-election. So voters will choose between two first-time candidates for this job. That doesn't mean that either of them is inexperienced. Both of them are actually very seasoned, and both in criminal defense and in administrative legal work. Ms. Easter worked with a nonprofit defense organization in the Bronx before returning to Orlando, where she went to law school. And Ms. Vickers, now in private practice, she spent 20 years with the Orange and Osceola Public Defender Office, and at one time was Mr. Wesley's second in command. The political relationships in this race are best described as complicated. And we could spend the entire allotted time probably talking about them. However, that would leave you, the voters, with not much information about the race itself and what each of these candidates would do if elected. So instead, we're going to ask both of you to focus on the issues before the public defender's office, the challenges, and just remember that we're looking to give voters a good idea of who would do the best job in handling this very important function. And I would like to begin with the first question. If you ask any public defender what their biggest challenge is, they'll probably say it's hiring and keeping enough attorneys to handle the workload. In Florida, the annual turnover is reported to be well above 20%, despite the fact that the legislature did allocate money for modest raises over the last 2 years. What would you do differently to recruit and train new attorneys, and what steps would you take to hold on to them? And let's start with Ms. Easter.
Thank you. I appreciate that question. You're correct. Turnover is huge among many public defense offices across the nation. And I know because I work with many of them. In order to be able to retain our attorneys, we have to somewhat make it interesting for them to want to work there. So the first thing what I would do is, of course, I would also continue to advocate for more funding so that we can increase those raises on a yearly basis. Another thing that I would do that I don't think is being done in this office is professional development. I would ensure that we would be able to send our attorneys to conferences so that they can engage with other public defenders, that they would be able to learn more about public defense, not just what's going on in Orlando, but see it from varying perspectives as I have been able to do. I would also foster an atmosphere where I would allow my assistant public defenders to come to me and talk to me about what they think is something that they would want to implement or do in the office. That is how I started the early defense team. When it got to a point that I kind of was just in and out of court all the time, and I saw that there was a gap in services, I went to my supervisor and talked about an idea about starting an early defense team. And I was supported by doing that. And it became a thing in 2019. So I would foster an atmosphere where I would allow my APDs to come to me and talk about things that they would want to implement to be able to do more things for our clients and do more things to make the work more interesting for them to be able to retain them in our office.
Thank you. Ms. Vickers, what are your ideas on hiring and keeping attorneys?
So thank you so much for having us today. While I was at the Public Defender's Office, I was in charge of recruiting, hiring, firing, all of that. So I'm very familiar with the work of hiring attorneys and retaining them. I think number one, we need to train them. There has been a lack of training in the last 5 years since I've departed the office, and that needs to be stepped up for sure. Another issue is that the attorneys don't feel appreciated. So a lot of it is morale driven, making sure the attorneys know that they are appreciated. The work is very, very difficult that they do, and it takes a toll on them. Many people take this work home with them. It's emotional. People are going to jail. Families are being split apart. It's hard. And so it's important to make them feel confident in their jobs by training, and also make them feel like they're appreciated. The other thing I'm going to do is we're going to rejoin the Florida Public Defender Association that does fantastic trainings all over the state. The current public defender decided to get out of the organization back in the 2000s, and I've already spoken with the president of the organizations who said we will be welcomed back with open arms. It's an organization made up of the elected public defenders in Florida, and they provide a lot of support and training to each other. And so I think having that unity around the state will also help attorneys feel like they're not only part of this office, but part of a bigger mission. And when you have that instilled in people, I think that it makes them want to stay, and it makes them passionate about the work they do.
Thank you. I have another follow-up about budget. There are other constraints, many constraints related to money on public defenders. One of them is the resources needed to investigate the scientific validity of forensic evidence, including DNA, which many lay people regard as the gold standard, but which I'm sure both of you know is frequently successfully challenged by lawyers who have the right resources. Does the Ninth Circuit have the capacity it needs for expert witnesses, scientific testing, and other means to ensure that this highly technical, highly scientific evidence is thoroughly and accurately explained to juries? And we'll start with Ms. Vickers.
Thank you. So we do have resources to hire experts in order to test DNA, test drugs, test other things that need to be done in order to ensure that our clients are receiving a fair trial. The concern is that we have to make sure that we have the budget for it. So in order to do that, we have supervisors who will approve or decline requests for experts when needed. Obviously, you have to go through and evaluate the case and what the evidence is, and are we even going to be able to test it? Is there enough substance to test? In that case, obviously, you're not going to spend money on any type of expert, but on the cases where you do have viable evidence to test, we would spend the money and hire experts to do that. The concern, though, again, is the budget. You have to make sure that you're using it wisely and that you're paying attention to what you're spending and how you're spending it. But we have used many, many experts in the past, not only on DNA and science, drugs, psychological testing, things like that. So it is definitely possible and capable.
Thank you. Ms. Easter.
Yes, I will say that, yes, it is possible for us to be able to do that. It is my understanding that this office has about a $20 million general revenue budget every year with 220 staff people, but only really on 185 that are in the office. And so it would be very important to make sure that, you know, we're doing the right things by paying our salaries to our attorneys. But then, yes, for forensics and for DNA type of cases, we would make sure that we would have the money to be able to pay for these experts to come in. And what I've learned in the work that I do at Partners for Justice, when you don't have maybe budgets to do certain programmatic things, you can go outside and look for grants to be able to supplement that. You can also look into philanthropic avenues as well. And I've had experience in being able to do that with offices across the nation, even offices that are state agencies such as the Ninth Circuit's office. And so we would make sure that cases that clients are getting fair and equitable treatment. And if that requires us to invest and make sure that we have the right services, such as having experts come in, we would make sure that we have the money to do that.
Thank you for that answer. I'll step in with the next question. I wanted to ask you about the language barrier. A lot of residents sometimes have a language barrier where it's difficult for them to adequately participate in their own defense. In the courtroom, obviously, they're supposed to get some help with translation, but are they getting that now? And do assistant public defenders also have the resources to communicate with their clients outside the courtroom? Basically, what are the issues there in terms of the language barrier? And we'll start with Ms. Easter.
Yes, that you raise a really good point. We have diversity in our office, so we have individuals who speak various languages, such as Spanish or Creole, to be able to help when it comes to interpretation. There's also Language Line, where you can use it. It's a service that you can call in, and they have an interpreter on the phone that can help when you are meeting with your client, so that you are able to have a meeting that makes sense and that you are able to understand your client is able to understand you. As you stated, the court provides interpreters for cases when there is, when the person speaks another language other than English. But I would say we are, under my leadership, we will make sure that every client, regardless of whatever language they speak, we would have services for them. Like I said, whether that is having someone in the office that speaks that language that can then interpret for the client, or using services such as Language Line to help in those situations.
Thank you. Ms. Vickers, same question.
Thank you. So the challenge becomes when the person's in jail, what do you do if they speak another language? Because we don't have access to internet and we don't have access to phones while we're in the jail. So if you want to go visit somebody in person who's in jail, you have to bring either a physical interpreter with you, or you have to have an attorney that does speak that language. So first of all, we're going to make sure that our attorneys are made up of a diverse group of people who have various languages. And then we're going to pair the attorneys with the language abilities up with the clients who need that language. That's important to do, and I don't think that's being done right now at all, and it should be done. So that is definitely something under my administration that we will be doing. The other issue is that you have to spend money to hire interpreters to go out to the jail with you, which again is another budget issue that you have to pay attention to. So in order to do that, you can get somewhat creative with it. There are different interpretation schools. There are different internships where people are learning to do language. The challenge is you have to make sure that they are trained in criminal justice language and explaining it the correct way, because guilty and not guilty and things like that don't always translate as easily. So they have to be skilled in the criminal justice language. So I will ensure that our clients definitely in the jail are getting the services. And as Ms. Easter said, when they're in the office, it's easy. You can pick up the phone and call Language Line. And then when you're in court, they do provide. It does, though, take a bit more scheduling when you do have a client who speaks another language that we don't have on hand. For example, right now, I have a client from Uzbekistan who speaks Uzbeki. And so we are having to wait 3 months in order to get a hearing just to have interpreters there for the hearing. So I know it's a challenge, but it's something that we will work through as a circuit at an administrative level with the judges, the state attorney's office, and the court interpreter services.
Thank you. You mentioned Language Line, which is sort of a lower tech end of this, but I did want to ask you about technology. I know that a lot of public defenders' offices are experimenting with technology, and I've heard of some using artificial intelligence to process documents and research cases. What, in terms of that and other uses of technology, do you think that the Ninth Circuit should consider? And I'll start with Ms. Vickers.
So when we went virtual, we switched from paper files to a case management system that was online. I was responsible for making that transition for the office. And after that, I was responsible for innovating that to see what different things we could do with that technology. And I'm very proud to say that under my leadership, it's a program that many state attorney and public defender offices in the state use, that we were the furthest along in innovating in using that program. So we will continue to innovate with technology. For artificial intelligence, obviously you have to be very careful and ensure that it is correct. When, for example, if you're using it for motions, you have to go back and check the case sites. It's not a substitute for rechecking the work. It can be a framework, a good framework to start with, to give, you know, some information on a particular issue, but you have got to cross-check. So it's not obsolete and not going to take the place of attorneys when writing motions and things like that. The other innovations would be working with the jails in order to be able to have more technology in the jails, because it's helpful when we have to show videos and photographs to clients. We're allowed to bring in a laptop as a public defender, but we don't have any internet access. We can't, you know, do things interactively with them. And so I would work closely with the jail to ensure that we have more capabilities, especially for our clients who are incarcerated, because when they're out of jail, they can come to the office, you can show them, you can use the technology. But it's definitely something that we will work towards as far as using all of the technology available. And I'm proud to say, again, we were on the forefront of that all along.
Technology in this day and age is a must. After COVID, we see that that is the way that most people communicate, and that should be no different for the public defender's office. Ms. Vickers spoke about different ways of technology being used within the office. I do know that when I was in the Bronx, as well as when I was at the Ninth Circuit, we were able to see our clients via video. So if we couldn't make it out to the jail, we were able to see them through a video and be able to talk with them for those times when maybe we couldn't make it out physically to the jail. It's important to make sure. I know that there are some courts that are still doing things in a virtual way. And so I agree that we must make sure that technology is a part of the equation when we're talking about moving public defense in a forward motion. I will say, and I agree that AI is good as a support, something that you can use maybe if you're, you know, stuck on an idea and you want to kind of make it more clearer, but I don't think that it should be the end all be all. People still need to bring their own creativity. You went to law school, and so you have that creativity in you, and that you should be able to use that. But I do think AI is okay, just kind of help in those moments when you get stuck, or you want to make sure things are a little bit more clear as to the way that you're saying it, but not for your actual point of view and your idea.
So I wanted to ask a few management questions. So, and we'll start with Ms. Vickers. What do you think are the best measures of an assistant public defender's performance, and what qualities do you think should be rewarded and what should be discouraged?
So that's a great question. Through the case management system, you have the capability as a manager to audit cases. So when I was there, we were auditing regularly. And since I've left, my understanding is that that's not happening anymore, which is a real shame, because you can go through a caseload very easily and quickly and see who is seeing clients in the jail, who is talking to clients in their office or on the phone, who is writing motions, who is not doing anything at all. So number one, we are going to bring back auditing because it's a great measure. Also, you have to be in court. As a supervisor, you have to go to court. You have to watch attorneys in court. And that's something that I was very proactive in doing. I would always go to court and say, hey, what are you doing today? Can I help you? What do you got going on? And I would watch and I would observe and I would jump in when needed. So that's number one, needs to happen. As far as rewarding good behavior, people who are consistent. You know, they say public defenders get a really bad rap for not communicating with clients. So communication with clients is going to be a very top priority for me. And so attorneys that communicate regularly with their clients are going to be rewarded for that. Also, attorneys that are thorough in research and writing and really fighting hard are going to be rewarded. What is going to be discouraged is not seeing your clients only on video. While I know it's a good substitute sometimes, there is no substitute for having that face-to-face interaction with a client. So we are going to have as many face-to-face conversations with our clients as we can. And that will be, you know, obviously rewarded, but then discouraged not to do that. The other discouraging thing is to not do your work. There's some people who don't want to work. They want to go to court and they want to be in court, and then they don't want to go do the background work. You have to research, you have to write, you have to communicate. It is all part of the job. So those things will be discouraged.
Thank you. Ms. Easter, same question.
Yeah, so I will say that, yes, there has to be a mechanism in place where you can keep up with your APD's work flow and workload. But you want to do it in a way where they don't feel policed. I supervised a team where I had access to their files, I had access to their cases. And what we did is we met on a weekly basis and we did what's called case rounds. We talked about their cases. We talked about the hard, the things that they found difficult, the things that they found that were challenging. We talked about the good facts. We talked about the bad facts. We prepared for trial. That makes your APDs feel supported, makes them feel that you are there. They can come to you. They have an open door policy where they will be able to come in and run things by you, as opposed to feeling like they're being audited and policed. I do believe that, this job is hard. I was an APD for, about 13 out of my 15 years, and it's hard. And so we want to make sure that we are uplifting, we are empowering, and we are rewarding those who are doing the right things, those who are communicating with their clients, those who are thinking outside of the box and coming up with creative ways to defend their clients at trial or through a hearing. We want to also, yes, we want to discourage people who are not doing what they need to do for their clients. I plan to bring a client-centered focus to the office under a holistic model. And that means that we have to, one, work together with social workers and investigators and with our clients, and to be able to foster the best result for them in the end. And that means that we have to have attorneys that are doing that. And those who are not, it's a conversation. We have a conversation, because there may be things going on in their life personally. There may be things going on professionally that we have to find out what is the root cause of maybe why they're not doing or meeting their expectations. And then we will have to deal with that accordingly if we're not. That's kind of something that will be happening on a yearly basis, which is performance reviews.
Thank you for that. Chris, do you want to take over?
There is another wrinkle to this, and that criminal courts are classically seen as adversarial situations. But the reality is that prosecutors, defenders, judges, clerks, and other courtroom personnel often come to function as a team, and build relationships with each other that make them, in some cases, vastly more efficient. But these relationships can also overshadow the client's claim to individual justice, to being heard as opposed to just being moved along, and even put them at risk of an unjust outcome. As public defenders, as the public defender, how would you keep tabs on each of your attorneys to make sure this isn't happening? Because it might not show up in an audit. So let's start with Ms. Easter. Sorry.
Yes, and it goes back to my point of having conversations with your APDs. And as the public defender with 2 offices, 220 staff, you cannot do that personally yourself. So it's making sure that your supervisors and your managers are well trained and well versed in being able to keep an eye on their supervisees' work, but then making sure that they are having those conversations on a regular basis to make sure that they understand what's going on with the cases, so that they can utilize and leverage their ability, their skills, and the fact that now that they're a manager, to be able to give their supervisees ideas on maybe how to deal with clients in particular situations as these. It's really about making sure that the support is there for our APDs and the conversations are being had on a regular basis to monitor what is going on in their cases.
Thank you. Ms. Vickers.
Thank you. So you have to go to court in order to see what's going on. You have to physically be present. And so that is something that absolutely we will do. As I stated earlier, I was very proactive in going to court and seeing what was going on pretty regularly. On an administrative level, it's important to be meeting with the judges. It's important to be meeting with administrators at the state attorney's office, corrections, sheriff's office, probation, all of those groups. All of those things I have done. I have been building relationships in this community for the last 23 years, and I have excellent relationships with all of those people in administrative offices. So I think it's having communications with them as to, hey, what's going on in your courtroom? What do you see is going on? And then seeing it for yourself. Also, of course, speaking with the attorneys regularly is something that's extremely important. When I was there, all managers would have a sofa in their office that attorneys could come in, plop down, talk about what's going on. And it's a good opportunity to say, hey, what's going on in your courtroom? Are you getting along with the state attorney? Are you not? Is there problems that, you know, are not adversarial, that it goes way too far beyond that? And do we need to intervene? And I do have a track record of intervening when necessary to either move an attorney or calling the state attorney's office and said, we need to move these people. They can't be in the same division together. How are we going to make that work? You also have the flip side of that, where you feel if attorneys are getting too close or too friendly. First of all, that shouldn't be happening in open court in front of the clients. It's not appropriate. If you want to be friendly with somebody outside the court, that's your right, and you can absolutely do that. And there's nothing wrong with that. But when you're in court, it is adversarial, and you need to maintain that adversarial nature of the relationship when you're fighting for clients' rights. These are serious cases where people are losing their liberty, losing their families, losing everything they have. And we need to take it seriously. And we need to make sure that we are acting appropriately in court and then following up on that.
Thank you. Thank you very much. And I wanted to ask you about a couple of other very difficult situations that do arise for public defenders. As you two both know very well, most cases, the vast majority of cases, are resolved through settlements, either plea agreements or dismissed charges. And defendants are very, very heavily reliant on their public defender for advice on how to choose. Under what circumstances should, if any, should a public defender encourage a client to take a plea deal, even if the attorney is convinced that that client is likely innocent? Start with Ms. Vickers on that one.
Okay. So in our criminal justice system, it's actually, can the state prove the case or can they not prove the case? And when you look at jury instructions, they all say, did the state prove their case? If they did, you should find the defendant guilty. If the state did not prove their case, you should find the defendant not guilty. So I try to approach it in a proven, not proven way. You have to get with the clients and educate them on that and make sure they understand. It's really not whether somebody did something or not. It's whether the state can prove it or not, because that's the standard of justice that we've been living by for 200 years. So it's important to make sure that the client knows that. I think it is inappropriate to pressure or force a client into pleading or going to trial. I think that the best practice is to lay out the good parts of the case, the bad parts of the case, tell them what the plea is, explain the risks of trial, what you think may happen in trial, what you think the evidence is going to show, what you believe the witnesses are going to say, and then help them make the decision from there. Answer their questions. Take time to go through that with them and make sure that they are educated and understanding. And that is something that we are going to focus on when I am public defender.
Thank you. Ms. Easter, same question.
Yes, never should an APD or a public defender force, pressure, or make a person take a plea. This is, I am a firm believer, as I stated a little while ago, about client-centered approach to public defense, which means that it is not the attorney that is making the decision. It is the client being involved in what is happening in their life. As Ms. Vickers stated, these are serious cases. This is the difference between somebody's liberty and somebody being able to go home to their family at night. They should be a part of the conversation, and they should ultimately make the decision that is best for them. I always, when I have a conversation with my clients, I always tell them, I cannot promise you that you will be found guilty or not guilty if we go to trial, but I promise you I will put forth the best defense that I can for you. And that means that I am going to give you all the information and lay it out for you and let you know what it is, what is the good, what is the bad, what can, these are what they have to prove. These are the elements, and this is the evidence that they have that can prove this or disprove this. It's kind of like going to a doctor's office, right? A doctor tells you, hey, you have to have surgery for this, this issue that you have. You want that doctor to give you all of the facts before you decide that you're either going to go to physical therapy or you're going to go and have this surgery. It's called what we call informed consent. So if a under my administration, if they're my APDs, I want them to have those conversations with the client and ultimately let the client make the decision if they want trial or if they want a disposition after they have given them all of the facts, all of the evidence, and let them know what it is that the client is looking at when they're talking about their case.
I think we have covered most of our questions. I really appreciate both of you taking the time to be here. What we will do now is move into, unless either Jay or Julie has another question. I'm sorry. Did either of you have another question?
I think we covered it.
Yeah. Well, I mean, there is so much more that we could ask you, but I really do appreciate you giving such thoughtful answers to the questions we've asked you. And then before I ask both of you to make your closing statements, I wanted to let our readers know the Orlando Sentinel will be making an endorsement in this race. However, we don't expect you to just take our word for it. And in fact, we urge voters, readers, to take a look. Both of these candidates have web presence, either through official websites, social media. You can see who your friends are interested in or what are like, and you can also do your own research into their legal backgrounds. There is so much information out there about many candidates. This race is a very important one because essentially the winner of this race is going to become the head of one of the biggest law firms in Central Florida, and they are charged with a massively important task. So we do urge you to vote, and this race, as I said, will be decided in the primary, and everybody who is a registered voter and has met the registration deadline gets to vote. So with that, I would like to ask both of our candidates to make their best pitch as to why they should get your vote on August 20th or before. And let's start with Ms. Easter.
Thank you. So the last two public defenders that were in this role were in there for at least 2 decades. And it's safe to say maybe this next person is going to be in there about the same time or maybe even longer. So it's really important because the stakes are really high as for the voters to make sure that they put the right person in this position. A person that has a vision, a person that is able to manage, and a person that is able to empower. We need someone that comes with a fresh perspective, a vast vision, and the ability to lay upon the foundation that Mr. Wesley has put in place. I have 15 years of experience, both locally and nationally. I have the ability to innovate programs. I have the ability to create visions, find gaps, and make things happen. I also have the ability to manage. I've managed an interdisciplinary team of social workers, attorneys, interns, investigators, and support staff. And right now, as a regional director, I oversee many programs in several states across the nation where we partner with chief public defenders to bring upon this transformation from traditional public defense to a holistic collaborative way of doing it. I'm also part of my senior leadership team here at Partners for Justice. So I'm in charge of the budget, I'm in charge of policies, I'm in charge of making sure that our office in my region is working and running correctly and is running efficiently. I have the managerial skills, I have the innovation and the ability to bring a vision to this office. And that is why the voters should choose me on or before August 20th, because we need a fresh perspective. The last 20 years we have changed, and I'm able to bring forth the change to take this office to the next level. So I thank you for your time.
Thank you so much. Ms. Vickers, want to wrap it up?
Yes, thank you so much for having me today. Mayor Dyer, when he endorsed me, said that I am the perfect person to be the next generational leader for this office. If you go on my website, which is www.vickers4pd.com, you will see all of the endorsements. I think the endorsements speak volume, and they're very, very important. You will see all of the elected officials that know me and trust me. You will see former judges, former attorneys, and former public defenders. I've got at least 50 former public defenders who have endorsed me to talk about my management, my leadership, my mentorship, and my abilities in the courtroom. So I've been a lawyer for 25 years. I was a public defender for 21 years, in management for 14 years at the office here, and served as the #2 in charge for 3 years before I left. I am board certified in criminal trial law, which means that in Florida, we have 72,000 lawyers, and 402 of them are board certified in criminal trial law. So that's a 0.005% that I am part of, and means that I am an expert in criminal trial law in Florida. I have proven leadership in this office. I have proven innovation in this office. I have proven mentorship and training. And the other thing that's really important in this race is that I have community. I've lived here for 23 years. My husband and I planted our careers and raised our children here. I have been developing relationships within the criminal justice and legal system for the last 23 years. I am able to call a judge and say, hi, we need to talk about a problem that we have. I'm able to work with judges when we have issues in the courtroom. I'm able to call across the state attorney's office and say, hi, we have a problem. How are we going to fix this? I'm able to talk to corrections, the sheriff. I'm able to do these things because they trust me, because they know me, because I've been here building these relationships. I would ask that you vote for me on August 20th, because I believe I have earned your vote at this point. Thank you.
Thank you so much. It's been a real pleasure spending some time hearing your views and ideas for this job. We wish you both the best of luck, and look forward to seeing what happens on August 20th.